Bridgeman Art Library v. Corel Corp. Bridgeman Art Library v. Corel Corp. 36 Fahrenheit. Sopra. Twad 191 SD NY 1999 was a decision by the United States District Court for the Southern District of New York, which ruled that exact photographic copies of public domain images could not be protected by copyright in the United States because the copies lack originality. Even though accurate reproductions might require a great deal of skill, experience, and effort, the key element to determine whether a work is copyrightable under U.S. law is originality. Copyright in the photographs. It licensed copies of its photographs for a fee. Action. Bridgeman sued Corel. It claimed that since no other photographs of the public domain works had been authorized other than those that Bridgeman itself had been authorized to make by the museums where the works were held, the only possible source for the digital images on Corel's CD-ROM was Bridgeman's own digitizations of its photographs. It claimed that since it owned the copyright on its photographs, Corel's copies were infringements of its copyright. Both parties moved for summary judgment. Judgment. Judge Lewis Kaplan in the Southern District Court of New York issued two judgments. First judgment. On November 13, 1998, Kaplan granted the defendant's motion for summary dismissal of the suit. The court applied UK law to determine whether the plaintiff's photographs were copyrightable in the first place, and applied US law to determine whether copyright had been infringed. It determined that Bridgeman's photographs were not original works, and could not be validly copyrighted under UK law. It further determined that even if the photographs were copyrightable, no infringement could be deemed to have occurred under US law, because the only way in which Bridgeman's and Corel's photographs were similar was that both are exact reproductions of public domain works of art, so the only similarity between the two works was an uncopyrightable element, the public domain material itself. Therefore, under well-settled US law, there could be no infringement. In the judgment, Kaplan noted that the court would have reached the same result had it applied US law throughout. Plaintiff motions. Thumb upright equals 0.9 Laughing Cavalier 1624 by Franz Hals. Bridgeman's image of this was the example used in the case. The entry of the first summary judgment caused the court, in the words of Kaplan, to be bombarded with additional submissions from the plaintiff. The plaintiff moved, on November 23, for reconsideration and re-argument on the grounds that the court's assessment of the copyrightability of the works was in error. In support of this motion, it pointed to a certificate of copyright issued by the United States Register of Copyrights for one of Bridgeman's photographs, a photograph of the Laughing Cavalier. It asserted that the certificate demonstrated the subsistence of copyright. It further argued that the court had misapplied UK copyright law by not following Graves' case. The court also received an unsolicited letter from William Fahrenheit Pattery, who argued that the court had been incorrect to apply UK law at all. The plaintiff moved for the court to receive an amicus curiae brief from the Wallace collection, addressing the UK law issue. The plaintiff's motions were granted. The amicus curiae brief was filed, both parties were given leave to address the points raised by Pattery's letter, and the case was re-argued and reconsidered. Kaplan commented on the plaintiff's motions in the subsequent summary judgment, saying, Second judgment. On February 26, 1999, Kaplan again granted the defendant's motion for a summary dismissal of the suit in a second summary judgment. In the judgment, Kaplan considered Pattery's arguments, the Copyright Clause in Article 1 of the United States Constitution, the Berne Convention for the Protection of Literary and Artistic Works, the Universal Copyright Convention, and the Berne Convention Implementation Act of 1988 BCA. In particular, he considered Sections 3 and 4 of the BCA, which amend Title 17, Chapter 1, Section 101 of the United States Code. The court inferred from the provisions of the BCA, and the absence of U.S. law to the contrary, that Congress had not granted foreign law the power to determine the issue of copyrightability in U.S. copyright actions. In other words, Congress did not adopt the second restatement's rule, under which the law of the state with the most direct relation to the property, i.e., the UK in this case, would apply. In particular, the wording of Section 4 of the BCA prohibits copyrights from being claimed by virtue of, or in reliance upon, the provisions of the Berne Convention or the adherence of the United States thereto. The application of UK law in the case would be in reliance upon the Berne Convention, therefore it could not apply and US law should be used to determine the copyrightability of the Bridgeman photographs. Thus Kaplan applied US law to the issue of copyrightability, rather than UK law as in the first judgment. The second judgment provided a more detailed statement of the court's reasoning than the first judgment did. The court held that photographs were writings within the meaning of the Copyright Clause. It cited Melville Nimmer's Nimmer on copyright, which stated that there appear to be at least two situations in which a photograph should be denied copyright for lack of originality. Kaplan considered one of those situations, as described by Nimmer, to be directly relevant, namely that where a photograph of a photograph or other printed matter is made that amounts to nothing more than slavish copying. A slavish photographic copy of a painting thus, according to Nimmer, lacks originality and thus copyrightability under the U.S. Copyright Act. Kaplan stated that there is little doubt that many photographs, probably the overwhelming majority, reflect at least the modest amount of originality required for copyright protection, citing prior judgments that had stated that limits of originality may include posing the subjects, lighting, angle, selection of film and camera, evoking the desired expression, and almost any other variant involved. But he ruled that the plaintiff, by its own admission, had performed slavish copying, which did not qualify for copyright protection. Indeed, he elaborated, the point of the exercise was to reproduce the underlying works with absolute fidelity. He noted that it is uncontested that Bridgeman's images are substantially exact reproductions of public domain works, albeit in a different medium. Although the second judgment was based upon application of U.S. law, Kaplan added that while the court's conclusion as to the law governing copyrightability renders the point moot, the court is persuaded that plaintiff's copyright claim would fail even if the governing law were that of the United Kingdom. He referred to a Privy Council case of Intellego v Tyco Industries for equivalent case law in the UK, where it had been held that kill, labour or judgment merely in the process of copying cannot confer originality. Further, the Privy Council had held in Intellego that here must be some element of material alteration or embellishment which suffices to make the totality of the work an original work, rendering the mere change in medium of a work, on its own, not sufficient for copyrightability. Thus the question of originality and copyrightability of a slavish copy, even one where the medium changed i.e. from a painting to a photograph, and thence to a digitization of that photograph, would be decided the same under UK law as under US law. Subsequent jurisprudence. As the decision of a federal district court, Bridgeman is not binding precedent on other federal or state courts, but it has nevertheless been highly influential as persuasive authority, and is widely followed by other federal courts. Several federal courts have followed the ruling in Bridgeman. In Meshworks v. Toyota, 528 F. 31258 10th 2008, the Court of Appeals for the 10th Circuit favorably cited Bridgeman v. Corel, extending the reasoning in Bridgeman to cover 3D wireframe meshes of existing 3D objects. The appeals court wrote, "The law is becoming increasingly clear. One possesses no copyright interest in reproductions, when these reproductions do nothing more than accurately convey the underlying image." Specifically following Bridgeman, the appeals court wrote, "In Bridgeman Art Library, the court examined whether color transparencies of public domain works of art were sufficiently original for copyright protection, ultimately holding that, as exact photographic copies of public domain works of art, they were not." The Meshworks opinion also revisited a 1959 case, Other Studios, Inc. v. Winninger, 177 Fahrenheit. Top 265 SD and Y, 1959, in which the district court enforced a copyright claim on a reproduction sculpture of Rodin's Hand of God. The Meshworks decision, however, specifically overturned that case. We are not convinced that the single case to which we are pointed where copyright was awarded for slavish copy remains good law. The appeals court ruling cited and followed the United States Supreme Court decision in Face Publications v. Rural Telephone Service 1991, explicitly rejecting difficulty of labor or expense as a consideration in copyrightability. This line of reasoning has been followed in other cases, such as Eastern America Trio Products v. Tyne Electronic Corp. 54 USB Qt Wad 1776 1791 SD and Y 2000, where it was ruled that here is a very broad scope for copyright in photographs, encompassing almost any photograph that reflects more than slavish copying. The Bridgeman case has caused great concern among some museums, many of which receive income from licensing photographic reproductions of objects and works in their collections. Some of them have argued, as above, that the case has limited precedential value, or that even though it was a federal court case it has no application outside of the state of New York. Others who reject the judgment on the Bridgeman case have pointed to Skiffer Publishing v. Chronicle Books as providing a contrary decision. However, in Skiffer, the facts of the case differed. In particular, the plaintiff had not been making any attempt at full fidelity with the works being photographed, and thus the photographs comprised an element of originality. As stated in Skiffer, the tone and value of colours in the Skiffer photograph differed from those of the actual fabric swatch, meaning that not only was fidelity not achieved, but in fact the photographs were visibly inaccurate representations of the works photographed. The presiding judge in the case, Judge Burrell M. Schiller, cited Bridgeman and went to great lengths to demonstrate that the material facts of Skiffer differ from those of Bridgeman. Beilstein concludes from this that far from Skiffer contradicting Bridgeman, it actually reinforces it and builds upon it, confirming that an interpretive dimension or spark of originality over and above slavish copying conferred originality and copyrightability. Relevance to UK law. As a US court case, Bridgeman Art Library v. Corel Corporation is not binding upon UK courts. However, because it follows dicta in intellego and cites Justice Laddie, it serves to raise doubt in UK law as to the originality of photographs that exactly replicate other works of art. An additional problem with taking the case as precedent would be reconciling it with the decision in Walter v. Lane, given that an analogy can be made between the skills exercised by a journalist in verbatim reporting of a speech and the skills exercised by a photographer in exactly reproducing a work of art. However, and a quest portfolio, Com v. Rodney Fitch and Amp Company also held that a slavish copy, such as reusing a photographic negative, rephotographing a print, or recreating the effect of an earlier photograph, would not constitute an original work. Similarly, Lord Oliver's dicta in intellego held that the effort of copying itself does not constitute originality. The significance of the case and the doubts that it raised prompted the Private Museums Copyright Group in the UK to commission an in-depth report on the case and to seek the opinion of Jonathan Rayner James, QC, a barrister who specialised in UK copyright law and a co-author of Coppinger and Scone James on copyright. Rayner James' opinion, as reported by the group in a press release, was: Stokes 2001 argued that, under UK law, the photography of such works, by dint of the lighting and other techniques involved in producing a photograph that renders the work to best photographic effect possibly better than what would be visible to a person viewing the original painting on display in the relevant museum, would constitute originality, per Laddie, and not merely a slavish copy. However, the review of UK authorities in the second judgment of Bridgeman Art Library v. Corel Corporation does highlight several points in UK law. For example, it draws attention to the fact that Graves' case, dating as it does from 1867, no longer reflects the law of originality in the UK in light of later cases such as intellego. The Bridgeman Art Library itself stated in 2006 that it is looking for a similar test case in the UK or Europe to fight which would strengthen position. In November 2015, the Intellectual Property Office of the United Kingdom issued an official guide for individuals and businesses titled Copyright Notice, Digital Images, Photographs and the Internet that offers a judgment similar to that of Bridgeman v. Corel. Updated for January 2021, the section of the guidance titled Our Digitized Copies of Older Images Protected by Copyright states that in November 2017, 27 prominent art historians, museum curators and critics including Benda Grosvenor, Waldemar Janicek, Martin Kemp, Janina Ramirez, Robin Simon, David Salkin, Hugh Belsey, Sir Nicholas Goodison, and Malcolm Rogers wrote to the Times newspaper to urge that fees charged by the UK National Museums to reproduce images of historic paintings, prints and drawings are unjustified and should be abolished. They commented that museums claim they create a new copyright when making a faithful reproduction of a 2D artwork by photography or scanning, but it is doubtful that the law supports this. They argued that the fees inhibit the dissemination of knowledge, the very purpose of public museums and galleries, and so pose a serious threat to art history. They therefore advised the UK National Museums to follow the example of a growing number of international museums such as the Netherlands Rijksmuseum and provide open access to images of publicly owned, out of copyright paintings, prints and drawings so that they are free for the public to reproduce.